Donna, you can proceed.
Welcome to today's program titled Guidance on State and Local Paid Sick Leave and Paid Sick Time Off Laws, Part 14, 2024 Paid Sick Leave Law Updates Reached from Coast to Coast. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Great, thanks, Donna. Hi, everyone. Good morning, good afternoon. Thank you so much for joining us today for the next segment of our Paid Sick Leave webinar series. This is our second webinar in the series in just the last couple of weeks, part 14 overall. Really excited to be with you today. Last week during our webinar, we covered two of the hottest areas of paid sick leave PTO law activity, those being in Illinois and Minnesota with the Illinois PTO law at the state level and the local laws in places like Chicago and Cook County, as well as amendments to the Minnesota state paid sick leave law. So lots of going on in those two places. A lot of employers have had their eyes focused on those two states and the relevant localities from a paid sick leave and PTO law compliance perspective, and rightly so. However, just when you think it's safe to go back in the water and you have those locations buttoned up or get as close to compliance as you feel comfortable with, there are other jurisdictions that are constantly evaluating, tinkering with, or potentially in significant ways amending their respective paid sick leave and PTO law programs. And that is what we're here to discuss with you today, what's going on in the country outside of Illinois and Minnesota in this space. So joining me to deliver all of this information today are my wonderful colleagues, good friends, Kathy Feldman from our Los Angeles office, Christina Duslack from our Boston office, and Ashley Casey from New York. I'm Josh Seidman from New York as well, and very excited to be here with you all today. Next slide, please. So let's jump right in and go over the agenda for today's webinar. We're going to start with a quick national paid sick leave PTO law overview. We will then turn our attention to a number of state and local updates and activities that have occurred in the last 6 months. We'll start off with Christina in Connecticut and Massachusetts. We'll then turn to New York State and City, as well as some localities in Pennsylvania that Ashley will cover. We're then going to jump across the country out west to Colorado and California, and we'll have those updates from Kathy. And then I'll wrap up today with a few highlights about activity in Oregon and Washington State. And we'll wrap up with a paid sick leave PTO law outlook for the rest of 2024 and into 2025. Next slide, please. And one more. All right, so this is our national paid sick leave law overview slide. This is as helpful as we can get to try to keep everyone's bearings straight and what's going on in this landscape. As you can see, starting in the middle of this month, there were a total of 57 paid sick leave PTO laws around the country. That's down a bit from the end of 2020, which is sort of our point for comparison for assessing today's landscape. There were close to 70 total laws in the country going back about 3.5 years to late 2020, with the reason being that there were many COVID-specific paid leave laws in existence at that time. Now, this number has ebbed and flowed and gone up and down over the last 3.5 years, both due to sunsetting of COVID-specific paid leave mandates, as well as additions of new novel types of paid sick leave that fall under this paid sick leave law umbrella, or the sunsetting of standard laws, which, for example, just happened in Duluth, Minnesota, where the local paid sick leave law in Duluth was sunset earlier this year in light of the existence of the new statewide Minnesota paid sick leave law. The numbers, if you add up those three rightmost columns, the federal, the states, and the municipalities, they don't add up to 57. Probably, if you've attended our other webinars, you probably have heard us say the reason for that, but we'll reiterate it here, is because a number of these jurisdictions have more than one type of law that falls under the sick leave law umbrella. Okay, so what do we mean when we're talking about paid sick leave laws? We're talking about not just paid sick leave, but paid sick and safe time laws, paid safe time only laws, PTO, paid any reason leave laws, public health emergency leave laws, COVID-19 specific paid leave laws. Right? So there's a lot that goes into this term paid sick leave. And when you think about the scope, the breadth of that umbrella term, you realize that there are certain locations, Colorado being one of them, for example, that has both a standard paid sick leave, a general paid sick leave law, and also an interrelated but separate public health emergency paid leave component. In New York, as you'll hear about a little bit later on, there is a statewide general paid sick leave law, also a COVID-specific emergency leave law, and a third addition to that landscape that we'll discuss in a few minutes. So those are some examples of how you can have a location that has more than one mandate in this space. Finally, I'll wrap up my little overview here with a reminder that the locations that are highlighted in red in the state and municipal columns are the ones that we're going to be focusing on for today's presentation. So you can see California, Colorado, Connecticut, Massachusetts, New York, Oregon, and Washington at the state level, as well as a handful of municipalities, including New York City, Philadelphia, and Pittsburgh. So with that, I am going to pass it over to Christina to start us off with the first of our location-specific updates, and that is in Connecticut.
Thanks so much, Josh. Hi, everyone. All right, we can go to the next slide. So Connecticut was the first paid sick leave law passed in the United States. So it started this all off back in 2012. And as Josh covered, the number of states with paid sick leave laws has exploded in the past 12 years. And these laws and what they include have developed. They take from each other, they grow, but Connecticut was standing strong with its 2012 version. And so a lot of the updates are going to seem familiar when you look at kind of the landscape of what's typical. And there's a couple of exciting outliers that we're going to discuss as well. So these amendments were enacted just right in May. So this is fresh off the presses here. And the changes are going to go into effect January 1, 2025. So you have some time to get ready. The regulations have not been issued yet, so we definitely want to be watching for those because they might provide some additional guidance here. But the key changes are more employers are going to be required to provide sick leave under this law. More employees are going to be covered. We'll talk a little bit more about this, but Connecticut currently just covers service workers, and while it's a broad definition, it's still a limitation. And the law now expands to cover exempt employees who are exempt under the FLSA. There's additional requirements when you're using paid time off to comply with the law. There's a couple new provisions, and then I think one of the key things that we'll want to emphasize is, as of right now, there's no ability to request documentation for employees. The provision that allowed that was removed. So we'll talk a little bit more about that, but these are some of the key changes. Next slide. All right. So the current Connecticut paid sick leave law only applies to employers with 50 or more employees in the state. That is going to change on January 1st, 2025. And that's going to go down to 25 or more employees in the state. And I'm emphasizing in the state. So definitely note that. And then again, that will be reduced to 11 by January 1st, 2026. And then by January 2027, it's going to be, the employee threshold is going to be one or more employees in the state. So if you are on that line for employees in the state, you're going to want to look at your head count and assess it based on your payroll the week containing January 1st annually. Obviously, as this law, over the next few years and after 2027, this analysis isn't going to be as important. But if you're on the line and you're not providing coverage, you're going to want to be looking at that over the next few years. In terms of employer eligibility, it also removed, the amendments removed exemptions for certain manufacturers and nonprofits. They really only affected a limited number of folks. The current definition of employer is incredibly broad. It means basically any person, firm, business, educational institution, nonprofit agency, corporation, limited liability corporation, or any entity that meets the employee threshold. As we noted, definitely a broader definition of employer eligibility. And then in terms of who it excludes, self-employed individuals are excluded, and then a very specific type of construction-related tradesperson with certain CBAs that we don't need to go into the weeds with. If you think this could apply to you, definitely speak with counsel. All right, next slide. Employee eligibility has also expanded. So as I noted earlier, the current law only covers service workers, and that definition is defined by the Bureau of Labor Statistics website. And I can tell you the analysis can be quite complicated. The definition is broad. People who you wouldn't think are service workers are service workers. We're not going to have to worry about that after January 1st. It's not going to be by the type of work an employee does. Again, the law also is limited to employees who are hourly or non-exempt under the Fair Labor Standards Act. Again, that's going to be removed starting January 1st, 2025 with the new definition. The definition of employee does not include seasonal employees and that is defined as an employee who works 120 days or less per year. And that construction-related tradesperson with a multi-employer health plan, again, very specific, and you should speak with counsel if you have questions about whether or not your employee would fall into that category. Next slide. So there have been changes to the reasons for use. So you'll see these are pretty familiar. This is the current law, and it provides, an employee can take paid sick leave for illness, injury, health condition of the covered employee, or the covered employee's child or spouse. And we're going to cover this in a few slides, but that definition of who can be of a family member and who is covered for the employee's family member is going to be expanding. So that's going to kind of make these reasons for use get a lot broader. And that's going to be the same for the reason for use related to medical diagnosis or care or treatment for a mental or physical illness, injury, or health condition, and also preventative medical care as well. You all might recall that back in October 2023, not too long ago, Connecticut had amended its law to expand the reasons for use to cover a mental health wellness day. And this is pretty broad. And the statute defined it as a day during which a service worker could attend to such service worker's emotional or physical well-being in lieu of attending a regularly scheduled shift. And so it's incredibly broad, and so that reason for use still exists. And so that's something to note as well. The law also covers a covered employee, or covers an employee if they are a victim of family violence or sexual assault, or where they are a parent or a guardian of a child who is a victim of family violence. And that second provision was also, covering a parent or guardian of a child was also added in October 2023. All right, next slide. So in addition to that broader definition of family member to the already existing reasons for use, there are two new reasons for use. Again, you're going to see these in a lot of paid sick leave laws now, and it's essentially related to public health emergencies. So you have whether a public official orders closure of a business or a family member's school or place of care, and then also if a health authority or jurisdiction determines that, basically that the individual could pose a risk due to their exposure to a communicable illness. And they state here whether or not the employee or family member contracted the communicable illness. So additional reasons for use to note. Next slide. as we discussed, expanded family members previously and under the current law, it's just child or spouse, and spouse has that very narrow definition of a husband or wife. Now it's incredibly broad. Spouse, sibling, child without an age limit, grandparent, grandchild, parent of an employee, or an individual related to the employee by blood or affinity, whose close association with the employee shows to be the equivalent to those family relationships. So we're seeing that kind of last category in a lot of the new paid sick leave laws, and it's basically, who do you consider a family member? And the other thing to note about each of these categories, they cover each of these different relationships, whether they're by blood, marriage, adoption, or foster care placement. All right, next slide. So under the current law, employees are required to provide a maximum of 7 days notice for reasonable absences. Again, something that is very common in a number of sick leave jurisdictions. That is changing under the law. So the provision that required that notice has been removed. Employers can no longer require 7 days notice for reasonable absences, under the statute right now. Again, there could be some additional guidance in the regulations, although again, it's gone from the statute. So that's something to note. The other thing that I mentioned earlier that is a game changer is that under the current law, an employer could request reasonable documentation for paid sick leave of 3 or more consecutive days. That is no longer allowed. That provision has been removed from the law. And so without that provision, an employer cannot require documentation for covered paid sick leave, even if the employee is out for the full 40 hours that they're allowed to use under the law. So definitely something to look at your policies on and make an update, because again, this is something that, if you have a multi-state policy, this is a very typical provision that we see. So you want to definitely take a close look at that and make sure it aligns with the requirements in Connecticut. All right, next slide here. One of the oddities of the Connecticut law was the waiting period. It was the only jurisdiction that required covered workers to complete 680 hours of employment from their date of hire, and then they also had to work an average of 10 or more hours per week in the most recent calendar quarter to be able to use paid sick leave. That requirement's now gone. It is now updated to allow employees to begin using paid sick leave beginning on their 120th calendar day of employment. Again, you're going to see that in a lot of the paid sick leave laws now. A lot of them are 90. We're starting to see 120 to be more common. And just an extra compliance note is that this is when they're able to use the paid sick leave. As a reminder, employees need to be accruing paid sick leave at the time of hire. All right, next slide. So under the current law, employees are earning paid sick leave at a rate of 1 hour for every 40 hours worked. Under the amendments, that is faster. Now it's 1 hour for every 30 hours worked. So employees are going to get to their max of 40 hours of sick leave per year earlier. So action item is to program your paid sick leave tracking software and systems to calculate leave at a faster rate starting on January 1st, 2025. Next slide. All right. So under the current law, employees are allowed to carry over up to 40 hours of unused paid sick leave per year. No change under the amendments. But what has changed is that the current law has been silent on front loading. And what I mean by that is a common provision that we see is that for employers that don't want to have, carryover and kind of go through the administrative burdens of tracking that each year, an employer can provide the full amount of paid sick leave that an employee is eligible to receive for the year at the beginning of the year for immediate use. And the employee then does not carry over any unused sick leave to the next benefit year. So that now is in the law and allowed. So definitely something that is a welcome clarification. And the other thing to note, annual usage cap, there is no change. So even if you do stick with allowing employees to accrue the paid sick leave and carry it over, each year, employees are still limited to using 40 hours of paid sick leave per year, regardless of the amount of unused paid sick leave that they might have carried over from another year. All right, next slide. Other paid time off compliance. So this was allowed under the current law. It just was a little bit more narrow. So all that employers were just required to make sure that employees could use PTO for the same purposes as required under the Connecticut paid sick leave law, and that employees were accruing at a rate as fast or equal to or more generous than the law's requirements. So those same two provisions apply that are now, that are in the current law, but now the law specifically requires employers to also comply with documentation for paid sick leave requirements, aka not requesting documentation, treatment of unused paid sick leave at termination also needs to be the same as required under the law, and disciplining employees who use available paid sick leave for non-covered reasons as well. All right, next slide. Covered worker, so for payment, not a huge change here, but definitely one to note because it is so important when we're dealing with pay. Covered workers must be paid either their normal hourly rate or the minimum fair wage in effect for the pay period during which the employee used the paid sick leave. The amendments add language to state whichever is greater from the above requirements. So it clarifies that, from those two, you need to make sure that it's the greater amount, and this would come up in a situation where you have an employee who's making more than minimum wage. If they're making more than minimum wage in the pay period prior to the one in which they use the paid sick leave, they need to be paid at that higher rate. All right, so next slide. Exempt employees are now covered under the law, and we have some clarification that you're going to presume that they're working 40 hours per week unless the employee's normal week is less than 40 hours. All right, next slide. The other big note here is, in addition to displaying a poster, now you need to display a poster and provide written notice at the time of hire or January 1st, 2025, whichever is later. So please note that you need to start getting these notices out at the end of the year. The state has indicated they're going to create model posters. Also, there was clarification that employers without a physical workspace or teleworking employers with teleworkers can comply with this requirement, sending it via electronic communication. There's also a record keeping and balance notification requirement. So you must note on pay stubs the amount of hours accrued and used. You also have to retain records for 3 years, and you could be audited for this, and they're going to be doing audits related to this compliance. And you could be assessed civil penalties of not more than $100 for each violation of this provision. And then finally, there's some additional provisions related to replacement employees. You can't require an employee to find a replacement worker. And then employee transfers and successor employees. Basically, employees need to be able to keep what they accrued. All right, next slide. All right, so quick update. Massachusetts hasn't really had any major changes in a while. We just want to remind folks, if you go to the next slide, that this is a law that is actively enforced. There's been one update, not related to the earned sick time law, but related to the paid family medical leave law, that now employees can receive benefits from the state and top off with their earned sick time. So something to note there. We also want to remind folks to evaluate remote employees in accordance with the rules. The rules are a little bit outdated, but they do specifically address telecommuting. And it notes that even if an employee does not physically spend hours telecommuting in Massachusetts, they still could be covered depending on their contacts with the state. And we understand this could be a case-by-case analysis. So something we definitely want to flag is more and more folks are working remotely. And just evaluate your systems and your notice of posters, and make sure your folks are all trained on compliance. Thanks so much.
Okay, awesome. So I'll pick it up from here. So we're going to stick on the East Coast for a little bit, and I'll take us through some important updates in New York and New York City, and then we'll go over some local updates in Pennsylvania as well. So on the next slide, we'll start with New York State. So there have been some developments with respect to COVID-19 emergency leave, which I know our New York office in particular has been getting a lot of questions about lately. So the state's 2025 budget bill, which was approved very recently on April 20th, announced that COVID-19 leave will now end on July 31st, 2025. This is actually a full year after we expected the law to sunset. So this means employers still need to comply with the COVID-19 requirements for a little more than a year from now. So because of this, we'll just go through some of the requirements here. So essentially, this is just a separate leave available to New York State employees for COVID-19 related illnesses. And importantly, to be eligible, employees must be under a mandatory or a precautionary order of quarantine or isolation. And in terms of amount of leave available, the state is now following the CDC's new guidance on applicable quarantine and isolation periods, which was recently revised so they got rid of the 5-day quarantine period. So this means that the length of the employee's leave will depend on the type and severity of the symptoms. So this is a little bit of a change. So specifically, employees may return to work 24 hours after their symptoms have improved, or if they have a fever, within 24 hours after their fever is gone without the use of fever-reducing medication. Like I said, the leave will really depend on how severe the symptoms are and what kind of symptoms the employee is experiencing. And just as a reminder, even though this law will sunset on July 31st of 2025, employees can still use other paid leave, such as New York State paid sick leave, in the event that they experience COVID-19 symptoms after the sunset date. So they're not completely out of luck. And on the next slide, we'll stick with New York for a little bit. So another important update here is paid prenatal personal leave, which is the first of its kind. So it's a separate leave bank available to pregnant employees, and it's set to go into effect on January 1st of 2025. So essentially, this is a new entitlement under the existing New York State paid sick leave law. So some of the definitions likely still apply, including employee, which likely includes all private sector employees, and employer, which likely includes any employer who employs more than one individual. In terms of leave amounts, employees are entitled to 20 hours of paid prenatal leave, but because this is a separate leave bank and is in addition to New York State paid sick leave, eligible employees actually receive a combined amount of 60 or 76 hours of both prenatal and paid sick leave combined. So that's just an important note. And as you may expect, paid prenatal leave is available for pregnancy-related reasons. And this would include things like physical examinations, medical appointments, monitoring and testing, as well as discussions with healthcare providers. And on the next slide, another thing to be aware of is how paid prenatal leave may be used. So paid prenatal leave can only be used in hourly increments, and that would include things like 1 hour, 2 hours, 3 hours, and so on. Also, similar to the paid sick leave requirements, employees must be paid at their regular rate of pay or the applicable minimum wage at the time the leave is taken, whichever is greater. And another important point is just benefits must be paid in hourly increments. So that's specifically stated in the new statute. And finally, there are some other provisions that we recommend that you just be aware of, including that paid prenatal leave does not need to be paid out upon separation of employment, as well as employers may not disclose any confidential information that they receive, such as relating to the pregnant employee's medical appointments or the reasons why they may be using leave. Retaliation and discrimination for requesting or using prenatal leave is also prohibited, as well as when employees return from prenatal leave, they must be returned to their prior position with the same benefits and pay. And on the next slide, although we just went over a lot, there are several things that are still unclear right now because all we have is just the amendments to the law. So there are a few things that we don't know, which includes treatment of new hires, documentation, employee notice to the employer, balance notification, written policy requirements, as well as treatment of paid leave at the end of the year. But we anticipate that additional guidance will be released closer to the January 1st effective date that will hopefully answer many of these questions. And we'll definitely be watching that, and we'll publish some updates as soon as those are released. So now on the next slide, we're going to move it over a little bit to New York City. So now under ESTA, which is the Earned Safe and Sick Time Act, there's a private right of action. So this change is effective March 20th of 2024. So now, as of March 20th, 2024, employees can now sue employers in court for ESTA violations and seek various types of penalties, which are listed here, including compensatory damages, injunctive relief, attorney fees, as well as any other relief that the court may award. So this is quite a significant change because before this, you were only able to file a complaint with the Department of Consumer and Worker Protection, otherwise known as the DCWP. The amendment also includes a decent statute of limitations. So employees can now sue their employer within 2 years of the date they knew or they should have known about the violation. And as I noted, the DCWP traditionally enforced ESTA. So now as of March 20th, 2024, employees do not need to file a complaint with the DCWP at all. They can now go straight to court. But in the event that they do choose to file a lawsuit and a complaint with the DCWP will hold off on their investigation pending the outcome of the lawsuit. So they're going to try to work with the courts on determining the end result. And on the next slide, we'll stick with the DCWP for a little bit. So the DCWP releases yearly reports which break down statistics about paid sick leave claims from that year. And this normally lists topics which are listed on this screen here. So these statistics are very helpful and often demonstrate just how active the DCWP is in its enforcement of the sick leave law. So here we see that the DCWP received 221 complaints in 2022, and this number jumped to 298 in the following year, 2023. While the new private right of action may influence these numbers going forward, it's likely that the DCWP will not stop its enforcement by any means. And this is really evident by the fact that the DCWP just opened just under 100 more investigations in 2023 than 2022. So they're definitely ramping up rather than slowing down. And although the restitution and penalties, although the restitution number is a little bit down from 2022, the penalties increased about $40,000 in 2023. So it still shows that they're, actively enforcing this law and issuing penalties where they deem appropriate. And on the next slide shows one of the most crucial pieces of information we get from these reports, which is the types of claims being raised by employees. So this is really helpful so that way we can help counsel clients and see what employees are complaining about. So the types of claims are pretty similar between 2022 and 2023, which really underscores the fact that employees are most likely alleging that they were not being paid for using sick time and their employer did not have an adequate sick leave policy. So this is just, it goes to the point that these are two things that we really want to be focusing on because these are two items that keep coming up year after year. And as a reminder, final amended rules were issued in September of 2023 that slightly changed the written policy requirements for ESTA. So it's important that your policies are up to date to avoid one of the most common types of complaints. And we're happy to help with that if you have any questions. And moving on to the next few slides, we have a few updates for Pennsylvania, which we can go through. So the first one is Pennsylvania's COVID-19 leave law sunset on December 31st, 2023. So unlike New York, Pennsylvania is one step ahead of us, and they sunset a little bit earlier. So as we discussed in the New York section, employees are not completely out of luck, even though the law sunset. Philadelphia employees may now use paid leave or unpaid leave under the Philadelphia Promoting Healthy Families and Workplace Law for COVID-19 related illness. So this will be available to them going forward, as well as any other types of leave that they may be eligible to that would that COVID-19 would fall into. And next slide, we have some more updates. So the Pittsburgh Paid Sick Days Act. So there were some guidelines that were issued in 2023 that we just want to go over that are quite important. So the first one is accrual cap. So according to the guidelines, employers with less than 15 employees must now allow employees to accrue at least 24 hours of unpaid leave per calendar year. This is a change because the guidelines actually conflict with the ordinance. And the ordinance says that employers with less than 15 employees must allow accrual of paid leave. So there's a little bit of conflict between the two, but the 2023 guidelines are the city's binding PSL regulations. So if you have any questions about the interplay between the two, definitely reach out to council, and we'll be happy to help you navigate between these. Next slide, please. And finally, Pittsburgh is taking quite a stance in terms of enforcement. So their enforcement agency is the Office of Equal Protection. They first started in September of 2023 with an educational campaign, which was released on their website. And in that campaign, they also vowed to conduct compliance investigations into fast food service businesses in 2024 and listed a few different zip codes that they would be enforcing, including 15201 and 15203. So we're aware of investigations in these zip codes happening already, and we expect that the investigations are only going to continue, especially because the OEP released a statement in January, again, confirming their intent to go forward with the investigations. So this is definitely something to be aware of. And with that, I think we can move it now over to Colorado.
Thanks so much, Ashley. So diving right in on our next slide, we know the only constant in Colorado is change. We saw in the second half of 2023 some amendments to the state's Healthy Family and Workplaces Act, changing the reasons for use, adding additional reasons of use that are listed there. And in the first half of this year, they made some further changes to the HWFA, really three key changes that we will dive into on the next slide. So the first change impacts the rate of pay standards. So there we've got the prior standard for you, which is that rate of pay for paid sick leave is calculated on employee pay over the 30 calendar days prior to taking leave. But in effective April 1st of this year, the state gave employers additional flexibility with this standard. So you can still use the same 30 calendar day standard, or employers have the option to calculate the rate of pay using any full pay period or consecutive full pay periods or work weeks that total 28 to 31 days. This change also applies to the state's public health emergency leave as well. So important to note that it should be the same rate of pay standard across both leave categories. And on the next slide, another one of the changes that was implemented this year impacts how the paid sick leave hours are calculated. So in Colorado, the number of hours of paid sick leave that an employee can take is the number of hours that an employer reasonably anticipated they would have worked during the period of leave. And the state provided three options for determining that amount under this prior standard. Obviously, if the employee's been working a regular schedule, they're going to be working a regular schedule while they're on that period of leave. You can rely on the regular schedule of hours actually worked. But if during the period of leave the employee was going to depart from their regular schedule or work some type of a modified schedule, then you would rely on those anticipated different hours. And the one that's most critical to the new standard we have is this third option, where if you can't reasonably anticipate the number of hours an employee would work, then under the prior standard, you would use an average of the hours worked during the most recent 30 calendar days of work. And this was changed very similarly to the way that the rate of pay calculation was changed to now give employers the flexibility to either use that 30 calendar days of work or the most recent of any full pay period or consecutive full pay period or work weeks that total anywhere from 28 to 31 days. So really giving a little bit of an added benefit to employers in that way. And under both the hours calculation and the rate of pay calculation, obviously if you've got employers that are using this leave and they haven't been employed for a full 30-day duration or any other duration sort of less than 28 days, then you're using the prior standard setup instead. And moving on to the next slide, as we're seeing in some of these other jurisdictions as well, Colorado is also improving and increasing some of their enforcement provisions. And they've done that in 2 ways this year. The first way is that they have established a wage theft enforcement fund, and that applies for not just paid sick leave violations, but other investigations involving wage theft as well. And what this provision allows is there is a fund that's been established by the state where if an employer fails to fulfill an order by the division to pay an employee after there's been a determination, then the state can step in and pay the employee out of this fund. And that would happen within 6 months of the after the division issuing a citation that the employer hasn't responded to. And if the division actually has to be the one to pay the employee out of this fund, then the employee can't receive double payment. They can't then seek anything from the employer. They are considered to have been made whole. And the division then replaces the employee as the creditor. So they can continue to pursue the payment from the employer. The second enforcement measure that was implemented this year is that there's now expressly stated an opportunity for the state's Employment Division of Labor Standards and Statistics to invite or order parties to participate in some type of mediation or settlement conference to resolve any wage complaints or issues that are raised with the division. So definitely seeking to reach resolution of those types of complaints in a slightly more proactive way. And we're going to jump from there to California, which really always keeps it fun for employers. So we're going to cover on the next slide a little bit of a refresh for you on some of the changes that went into effect this year on January 1st. The first big ticket change was that the amount of paid sick leave that's required in California increased from 3 days or 24 hours to 5 days or 40 hours. And that's going to impact your paid sick leave policies, whether you are doing front loading or you are doing accrual. We're seeing increases kind of across the board. Similarly, accrual cap, which in California is a rolling point in time accrual cap, increased from 6 days or 48 hours to 10 days or 80 hours. We're not anticipating any changes to this law in this legislative cycle. The last legislative cycle, the amendment was passed in September of 2023 and effective, as we noted already, on January 1st, 2024. If there were going to be any changes, we would see those passed by the legislator no later than September 30th this year, but we're not anticipating that in this cycle. On the next slide, one thing that I think is particularly interesting and worth noting about the changes in California is what changed relative to CBA exemptions. So what we had previously was a complete exemption of the paid sick leave requirements if you had a CBA that expressly provided for each of the categories listed here. And under the amendments that went into effect this year, and even if you satisfy that criteria and your CBA expressly includes all of these points, it's still only a qualified exemption, and employers must still provide paid sick leave for the same reasons for use that are listed under the state's law. There still has to be anti-retaliation, meaning we can't retaliate against anyone for using any type of paid sick leave, and workers can't be required to find any replacements for the days or hours that they are absent. Moving on to the next slide, we're going to talk a little bit about the local jurisdictions in California. And this is a state where we've got our state law and then a lot of local requirements as well, some of which definitely keep things interesting. So first and foremost, there's a partial preemption under the amendments of the different paid sick leave ordinances, different substantive standards that we've listed here for your reference. In response to this partial preemption, we haven't seen any of the localities amend their respective laws, and most of them have not even put out any messaging around the amendments that went into place, other than San Diego, which essentially noted that there was state level amendments, but that the San Diego requirements, absent this partial preemption, still applied. We listed for you here the different locations where there are specific local ordinances. Los Angeles is an interesting one because we've got both a citywide ordinance and also an ordinance specifically for hotel workers. So that's something to keep in mind if you're in the hospitality space. And West Hollywood, our last one listed here, the trickiest of the bunch. It's definitely an outlier in California. It's the only PTO law in the state, and we've seen in prior years that the city has updated and made that standard more generous than it was before. The most recent updates there were in May of 2023. We're definitely tracking to see if there will be any further developments in that jurisdiction or any of the other localities in California where we see a lot of paid sick leave activity. While we're not seeing changes to the ordinances just yet, what we are definitely seeing is an uptick in local investigations, and the local agencies, particularly Los Angeles, have shown a really increased attention for paid sick leave violations or potential violations. I think we're still in the early days of how that's going to play out, and and what resources the agency in LA and others are going to be devoting to paid sick leave violations. But we're definitely tracking that as well. And with that, I will pass it over to Josh to tackle Oregon and Washington.
Great. Thank you, Kathy. Hi again, everyone. All right. So we've been jumping all over the country for the last 45 minutes or so, and we're going to land this plane in Oregon and Washington with some updates in both of those states. Next slide, please. So from an Oregon perspective, the law has been around for a number of years. 1 hour of paid sick leave for every 30 hours worked is the general accrual rate. There are 40-hour caps on accrual and usage and year-end carryover, and front-loading the right amount of time at the start of each year can get rid of your carryover and accrual tracking requirements. So fairly baseline set of sick leave standards compared certainly to some of the locations we've been discussing throughout the webinar today. There are also no localities with paid sick leave laws in Oregon, so different than New York, California, and elsewhere. There have been some recent updates in the Oregon paid sick leave world. A lot of these updates have been driven by the interplay between Paid Leave Oregon, which is the state's paid family medical leave program that went online in September of last year, the state's unpaid family medical leave law, the Oregon Family Leave Act, or OFLA, and the state's paid sick leave law, because there are some interconnected components, specific provisions of the paid sick leave law that cross-references those other laws, as well as the safe time law, unpaid safe time law in Oregon as well. So there's a lot of interconnectivity between these leave laws in the state, and changes in Paid Leave Oregon and OFLA have led to certain tinkerings, changes within the paid sick leave setup for Oregon as well. In addition, and related to all of this, back in March, Oregon amended its paid sick leave rules. The rules included amendments to both the OFLA rules and the paid sick leave rules, and those went into effect on March 2nd of this past March. So you'll see the topics that were impacted include covered reasons for use, the definition of family member, and documentation standards. Just want to talk through these with each of you for a couple of minutes. So next slide, please. All right, so this slide covers the current reasons for use under the Oregon paid sick leave law. These are, again, the reasons post-March 2024's amendments to the rules and interplaying and adding in the changes that are coming online for OFLA over the next couple of days, specifically on July 1st. So what you'll see from this list is that there are a lot of bullet points. And Oregon has historically, because of this interconnectivity with the unpaid OFLA in the state, has had quite a broad set of covered reasons compared to other paid sick leave laws around the country. For example, Oregon has historically, for their paid sick leave, covered bonding with a new child. It's also historically covered bereavement leave. Those are both outlier covered reasons and things that typically aren't the top of mind covered reasons from the paid sick leave law coverage perspective, but they have been in place in Oregon for a number of years. That is continuing to remain as is. However, the recipe for getting those covered reasons into the paid sick leave law in Oregon has changed. This is because Oregon, the OFLA, the Oregon Family Leave Act covered reasons, have been watered down greatly. They're being greatly reduced as of July 1st. They're no longer going to cover bonding with a new child or family member's serious health conditions or the employee's own serious health condition. Those reasons are now going to be exclusively covered by the paid family medical leave law or paid leave Oregon in the state starting July 1st. That has triggered the need for Oregon paid sick leave to add a cross-reference to paid leave Oregon and bring those covered reasons, or I suppose keep those covered reasons, bonding with a new child, family member, serious health, own serious health, expressly under the Oregon sick leave covered reasons by now incorporating the paid leave Oregon absences. So you can see the laundry list here. It is employee is sick, family member is sick, preventative medical care is also covered. The reasons under paid leave, under OFLA, which still include bereavement leave, so that will still be covered by the sick leave law. Safe time specific absences relating to being a victim of domestic violence, harassment, sexual assault, or stalking. You can allow workers to donate paid sick leave to coworkers if the company allows for those types of donations. There is a fairly lengthy list of covered public health emergency related absences under the Oregon sick time law, and you now have the paid leave Oregon covered reasons that are incorporated as well. So very lengthy list of what paid sick leave can be used for in Oregon. Next slide, please. Definition of family member in Oregon is also quite broad. It has added in addition to other general reasons, general family members, parent, child, spouse, grandparent, grandchild, sibling, and so forth, with definitions of many of those terms. Oregon has now also added in clarity that that covered family member includes an individual who is related by affinity to the employee. And they've added a definition of affinity, saying that basically, if it's a significant personal bond based on the totality of the circumstances, that person will be considered covered, right? It has to be comparable, equivalent to a family relationship. What Oregon also did, in keeping with this addition of affinity being sort of very clearly added to the covered family members, they've added in their documentation standards a new statement saying that if an employee is absent and using paid sick leave to care for a family member related by affinity, the employer can require written attestation from the employee, basically saying, hey, company, I, Joe Smith, share a significant bond with, input the person's name, and they are like a family member to me, right? And the regulations, these amended rules, include template language for companies to use for workers in providing this written attestation for workers to then submit to the company. So they also give examples of what would be considered comparable to a family member, what some of those facts might play out and look like in practice. Next slide, please. All right, so jumping over to Washington State, a different paid sick leave law, certainly, than Oregon, much more pro-employee setup, one of, frankly, my least favorite of the paid sick leave laws because of how complicated it is. 1 hour of sick leave for every 40 hours worked is the accrual rate, so a little bit slower than Oregon. But despite that slower accrual, Washington State is more pro-employee in a number of ways compared to Oregon, including that it does not allow for a cap on accrual or usage. It has the same 40-hour year-end carryover cap, but from a front-loading perspective, front-loading does not get rid of year-end carryover or accrual tracking in Washington State. So big challenges there for a lot of companies. And adding to the complexity is that there are localities with paid sick leave mandates that, especially in Seattle, diverge in some significant ways from the Washington State standard. So complexity abound in Washington State from a sick leave law compliance perspective. Washington State has historically tinkered with the contours of its paid sick leave law. It did this most recently in March through SB 5793, enacting certain amendments to the paid sick leave law. These amendments impact both the general paid sick leave law and the separate but interrelated transportation network company specific paid sick leave law. These amendments generally go into effect on January 1st of next year, 2025. And let's jump in and go through a couple of those amendments. Next slide, please. So what you can see here are reasons for use. Washington State has a fairly broad set of covered reasons, not as broad as the Oregon list that we just went over. Bonding with a new child, bereavement leave, for example, are not covered under the Washington State paid sick leave law for covered reasons. But one thing that the state has done, right, currently the sick leave law allows absences when the employee's child's school or place of care has been closed for a health-related reason, right? So sick leave is available for those closures. What the state has done, starting January 1, 2025, is expanded that covered reason. So now under the new law, employers will also need to allow employees to use their sick leave when their child's school or place of care has been closed after the declaration of an emergency by the relevant locality or a state governmental agency or by the federal government. So broadening that scope out, really in response to COVID-19 is what that feels like. Family member now has an expanded scope as well. In addition to, again, the usual parent, child, spouse, grandparent, grandchild, sibling, domestic partner, they have added a child's spouse to be explicitly stated as a covered family member. They've also added any individual who currently regularly resides in the employee's home and any individual where the relationship creates an expectation of care for that person and the individual depends on the employee for care. So a broadening of who is a covered family member in Washington State. Next slide, please. And finally, a note about construction industry employers. This flew under the radar, but is worth noting potentially as a breadcrumb that could lead to further changes in the sick leave space. There is a payout upon termination obligation for individuals employed under 90 days by a construction industry employer. This has been in place since January 1st of this year. So if a worker has earned sick time under the Washington State program but separates with less than 90 days having been employed, right, they are entitled to a payout of that accrued unused sick time. Again, only construction industry employers that this applies to. But this is an interesting wrinkle and could be something that leads to other jurisdictions, or maybe Washington State with its general paid sick leave law, adding a payout of sick time upon termination. That would, right now, this is the only paid sick leave law in the country that requires a payout of sick time benefit upon separation. There also have been amendments as recently as March of this year to this standard, clarifying who is considered a construction worker, the definition of a construction industry employer, the fact that there are some now FAQs that say that the payout obligation applies to both voluntary and involuntary separations, and they note that if an employee is rehired within a year, they do not have to have their sick leave that was paid out at separation reinstated when they're rehired, but the time that they work during that initial period of employment can be accumulated and added to satisfying a waiting period, again, if they're rehired within a year. So that takes us to Washington State. Next slide, please. All right, and we have one more slide, the quick outlook on what's coming down the pike here. We have some of the notes that we've mentioned already today. Connecticut with the paid sick leave amendment starting in January, same with paid prenatal leave in New York. The Chicago PTO paid sick leave law combo goes into effect for real on July 1st, so just in a few days from now on Monday. Minnesota's recent amendments to their paid sick leave law started just about a month ago on May 25th. Most of those amendments, although there are some that start July 1st and one big one that starts January 1st of next year. What could be coming later this year or in the coming legislative sessions? The big ones I want to point out of all the things listed here are numbers 2 and 3 under the state list. Nebraska and Missouri both have ballot initiatives on paid sick leave that are teed up, and I believe, I don't know absolutely, but I believe last I heard that they have obtained the necessary signatures to make it to a vote, to the ballot initiative for this upcoming election. Historically, when paid sick leave laws or the potential for a paid sick leave law is added as a ballot question, it gets enough votes to pass. So pay attention to that this coming election cycle. And also, will New York City add a PTO component to its law? mirroring what Chicago has done. That's another thing that we're paying attention to. All right, next slide, please. I'm going to read off the CLE code for folks who are interested. You can scan the barcode here, the QR code for to take you to the CLE page. The relevant data is here for you, and the CLE code is SS as in Seifert Shaw 3164. Again, that is SS as in Seifert Shaw 3164. Next slide, please. And one more. Finally, there's a lot that we've covered today and on our webinar last week. We have plenty of resources, great team members here that can help. We have premium surveys and paid sick leave and paid family leave that are available for subscription clients. If you want to reach out for more information, you can email us at paidleave@seifert.com. We also have a paid leave mailing list that you can sign up for to get all of our legal updates and blog posts, and podcast episodes, and webinar invites and so forth. So please do feel free to sign up. The link is there for your availability and use. Next slide, please. We also have other resources, including this webinar series. Again, part 14 was today. You can see the first 13 parts highlighted here for you. And we have a dedicated podcast on leaves and accommodations called Take It or Leave It that I have the pleasure of hosting, where we roll out episodes regularly with experts in this space. So thank you, everybody, for joining us today. I know we're at time, but to the extent folks want to hang on for just a minute or two, we've had some great questions come in, so I did want to try to answer one or two of these for folks. One of the questions, actually a couple of questions that came through regarding New York and this new paid personal prenatal leave, the PPPL, one of my new favorite acronyms in the space. Folks have asked about if they give a grant of time in terms of sick leave that is more than the 56 hours the New York State calls for. Do they have to, does the employer have to provide the additional paid prenatal leave, or can, from the paid prenatal leave setup, can the employer use that bucket of time, say an 80-hour bucket, for compliance with both the sick leave and the paid prenatal leave? I think this is a great question. From my perspective, it would be risky to use the existing sick leave benefit for compliance with the new paid prenatal leave mandate that starts up on January 1st. The paid prenatal leave, it has language in it that talks about it being above and beyond the New York State sick leave standards, so that creates some uncertainty, some risk with that approach. But the paid prenatal leave benefit in and of itself, even though, as Ashley said, it's kind of baked into the paid sick leave law, it creates some potential risk with allocating sick leave to comply with that benefit, because if the worker uses all their sick leave for something other than the covered paid prenatal leave reasons, and then has a covered need for paid prenatal leave down the road later that year, they don't have any time available for it, it feels like the state would not act kindly to that type of setup. So more to come. We'll see what regulations have to say. We'll see what more guidance has to say between now and the end of the year. But that is, the initial preliminary assessment of that. Ashley, I don't know, do you have anything to add on that? Have you dealt with that question at all?
Yeah, I agree. I think that per what we know right now, I think it should be a separate bucket. I think that additional guidance will definitely, or hopefully, be released prior to January 1st. But yeah, I would say that it's risky to use existing leave for this purpose.
Yeah, me as well. And then one other, just sticking with paid prenatal leave for one more second in New York, there was a question about, does it need to accrue, or is it simply time that can be used? From what we know right now, it is just time that can be used. Think of it as akin to like voting leave or jury duty leave or the other miscellaneous like bone marrow organ donation leave. It feels more akin to those than to a sick leave accrual, even though it's part of the sick leave law. So times are changing, I suppose. As far as, let's do one other quick question. We'll jump up to Connecticut, because we did get quite a few of those that came in. And rightly so, the Connecticut changes are quite complicated. So Christina, this one is for you. There was just sort of a question about, come the January 1st amendments, what is what's the eligibility going to look like as far as service worker, not service worker, exempt, non-exempt? Can you just go over that one more time for folks?
Of course. All right. So it'll be more employers are going to be covered. So it's pretty much all employers as long as they meet the employee threshold in the state. So on January 1st, 2025, if you have 25 or more employees in the state, you need to be providing them with paid sick leave. And that's regardless of whether or not they're a service worker. And that's because the employees who are eligible is broader. So it's not just service workers, it's all employees. And it includes both exempt and non-exempt employees under the FLSA. So it's no longer limited to service workers. So that's the thing to emphasize. It covers exempt workers under the FLSA, and you'll have to look at your, whether they work for an employer that is eligible under the law.
Perfect. Thank you, Christina. Yeah, the Connecticut changes, as Christina highlighted, are plentiful, and I would say different than what Chicago and Cook County and Illinois have done, where they've just expressly said, like, hey, here's a PTO law for you. You can use it for any reason. Connecticut has done what feels like kind of the same thing, but in a much more covert way, right? They're like, you can use this time, as Christina said, for mental health wellness days. That was an amendment from last year. But now you can't require documentation or have the employee provide notice, right? Those will be changes that are starting 1/1/25. And you kind of combine those two things, and it feels like we're getting into this paid personal time world in Connecticut. So thank you for the questions, and thank you, Christina, for all those details. I expect we will be covering Connecticut again in one of our webinars later this year where we get more guidance from the state. And the last question, then we'll call it for a day. I did see a good sort of high-level question, a few involving unlimited PTO, and one broader question asking for companies that have multi-state operations, which, given how remote and mobile workers are these days, feels like pretty much every company can be kind of a multi-state employer. What would be the best way to comply with the patchwork of sick leave laws? I'll say just at a high level, our team, including the four of us on this webinar, spend a vast amount of our day-to-day time counseling companies on this exact issue, right? Would it make sense to have a singular PTO policy that covers sick, vacation, and personal? Would it make sense to have separate buckets? And there are so many challenges with that assessment, but things that our team regularly helps companies navigate and sort through. There are legal compliance challenges, most notably that sick leave laws will typically say if you want to use PTO to comply, you have to apply the sick leave law conditions to the bucket, right, which can get very murky and very messy because a lot of those don't fit well in the PTO context. But there are many other considerations as well with that. So it depends on where you have your workforce, right, how mobile your workers are, how litigious your workforce might be, what the enforcement mechanisms and activity is in different states, as we spoke about for places like New York City and Massachusetts today. It's very active and aggressive. Pittsburgh, getting very active. Colorado, getting active. So a lot of these practical considerations will come into play, and we help our clients regularly navigate those concerns. So thank you, everybody, for joining us for today's webinar. We really appreciate it. You can reach out to any of us with questions, and we'll see you at the next session. Thanks so much.